Hello, this is Paul Callaghan, and welcome to our webinar on GDPR, a guide to it from an employment and HR perspective. You will no doubt have learned quite a lot about GDPR from the commercial contracts and customer information perspective. Today, for the next 30 minutes, we're going to focus on what you, if you're an HR professional or an in-house lawyer, need to be thinking about in terms of HR data. I head up the Employment, Pensions and Mobility Group at Taylor Wessing in London, and I'm joined by Sian Skelton, who is one of our partners specialising in data privacy, and also Steph Creed, who's an associate in the Employment Group, who's developed a particular niche in relation to HR data privacy issues. So Sian, just to get going, can you give us a bit of information, a bit of background on the GDPR more generally, and then we can get into the HR side in a bit more detail?
Thanks, Paul. The General Data Protection Regulation, or the GDPR for short, is coming into force in Europe in May 2018. The effect of GDPR is to, as far as possible, harmonise privacy law across Europe. Even though the UK has voted to leave Europe, we will still be adopting the GDPR into English law. So it's especially important for those businesses operating in the UK as well as across Europe to be aware of the implications of the GDPR. GDPR applies fundamental principles to processing of personal data, and some of these we'll be discussing today. So let's go back to basics. What does and to whom does the GDPR apply? GDPR applies to EU citizens only, and in the context of HR data, will apply to personal data that an employer collects and processes about an employee. And it could also include data that you collect about candidates during the recruitment process. So employers of EU employees will need to comply with the GDPR, even if their main operations are outside of the EU.
One of the sort of slightly more nuanced parts of this is that it's employees, but do remember it can also include other staff members, people like workers, casual workers, who you may not think of as being people you necessarily owe obligations to.
In other words, Steph, any sort of contract staff will be included as well, as what you're saying.
Yeah, precisely that. It's quite broad. So it's one to watch out for if you do have a flexible sort of workforce, or you have people who aren't necessarily you are seeing day to day. And it's going to cover things as well like monitoring those staff. Even if you are based in the US and monitoring from outside of Europe, that's one of the big changes that's sort of probably going to hit people a little bit harder than perhaps they might have thought. And decision making. If you are making decisions about things like bonuses, and you're making them outside of Europe or outside the UK, again, that's going to be caught because you'll be looking at the data, processing, assessing, and making decisions. So it's quite complex, and it's going to be in practice be a little bit thorny to try and work out who it applies to and how it's capturing them.
I think at this point it's for us just stepping back and thinking about what the definition of personal data is. The GDPR applies a wide definition of personal data. Those attending from the US will already know that the US has a concept of PII, but it's important to flag at this stage that the definition of personal data under the GDPR is much wider than the US concept of PII. Basically, personal data is any data from which a living individual can be identified, directly or indirectly. So for employees, this would include the name, contact details, payroll information, but would also include non-direct identifiers such as the employee number or an online identifier such as an IP address. I think Steph's got an example about emails as well.
It's one thing that we find in particular with employees is those off-the-cuff emails mentioning employees, referring to perhaps they're not very good at their job or you've had enough of them, they're annoying you. Those emails are already caught by the data protection legislation we have in place, but they're absolutely going to be caught by the GDPR. And it's those kinds of emails that in relation to employees are really uncomfortable and are going to cause you problems. So do watch out for that. And it's a good opportunity to refresh with your staff and your managers in particular that they shouldn't be making those kinds of comments on email, and they can come back to haunt them.
So if we now turn, so that's a basic broad outline of what the GDPR is. But if we turn to how employers in particular are affected.
The approach for employers under the current data protection legislation is relatively tight, but perhaps we haven't quite seen it bite as much as it will do under the GDPR. There are rules and regulations around how you should be processing employee data, but a lot of employers have tended to rely on contracts and contractual documents in order to be able to process data relating to staff. That is absolutely not going to work under the GDPR. It doesn't really work now, but no one's really looking into it. Under the GDPR, you are going to need another basis on which to process employee and staff data.
And this is important, presumably, because the fines under the GDPR are potentially huge, up to 4% of global revenue, I understand.
That's
Yeah.
absolutely correct.
No, it is, and it's something that perhaps we haven't seen in the employment context, simply because when you get a subject access request in, which tends to be where we see this the most, it's dealt with, but it's never seen as a bigger issue, particularly if there's litigation sitting in the background. Now it's absolutely going to be front and centre because of those fines that Paul and Sian have referenced.
So we often talk about how collection and use of personal data has to be fair and lawful, which is a very vague phrase. What does that actually mean in practice?
So this is a phrase and a concept that the GDPR is very clear about, and you're required to look at each type of personal data that you're collecting and be very transparent with the employees about the data that you collect, why you're collecting it, and how you're using that data. Is it reasonable, questioning all the time, is it reasonable for the employees to expect you to be collecting and using the data, their data, in such a way? With respect to each piece of data that you collect, you can apply a condition to the processing being undertaken. And these are conditions that are set out in the GDPR, and you'd need to go through a process of identifying the condition against the different types of data that you're collecting. So, for instance, is it necessary for the performance of the contract? So, for example, you do need to pay your employees. So, yes, it would be necessary for collection of payments, bank account details would be necessary for that. Is it necessary for you to comply with a legal obligation? An example of this would be your reporting to the HMRC or other statutory bodies as required under statutory legislation in the UK. Is it necessary for the purpose of the legitimate interest pursued by you? Here it's worth just pausing, because your legitimate interests as an employer are likely to be very different to the legitimate interests that an employee might expect you to have. So, for example, there are limits to this condition, and so you must be proportionate to the general privacy rights that the employees have, and that includes the general right for an employee to have a private life. The ICO, the Working Party, have issued some guidance specifically around employers' rights here, and have included examples such as if an employer deploys a data loss prevention tool to monitor employees' outgoing emails, to prevent unauthorised transmission of business confidential information, in order for the business to be able to rely on its legitimate interests, that is, protecting business data and protecting business confidential information, it must ensure that the employees are aware that they will be monitoring the emails, that the rules of the system which characterise an email as potential data breach are fully transparent to the employees, and that the employees are warned at the moment that they go to make that or send that email that they potentially are in breach of the requirements that the employer has laid down, and that give them the opportunity to cancel that email. It's quite specific guidance there from the Working Party around employee monitoring in particular, but it gives you a feel to just how transparent that you will need to be with your employees.
The big message that's coming from both the employment tribunals and from the courts more generally in terms of data protection is telling employees up front, making very clear so that they can be under no illusions what they're expected to do. That's partly a practical point of, if you've told them, it makes it much more difficult to say, I didn't know, I had no idea. But it's also giving them fair warning so that if they do breach it, they absolutely know that they're breaching it. The monitoring point that Sian's picked up is an interesting one. And it does mean that sort of privacy impact assessments are going to be probably much more needed in almost all cases for monitoring. And you're also going to need to think about why you're monitoring and do you actually need to do that. For home workers, for remote workers as well, things like keystroke monitoring, it's going to be very, very difficult to justify unless you can find a reason and actually come up with and back up why you need that to be carried out.
Okay, so moving on to subject access requests. Subject access requests are often a real burden at the moment for employers. Disgruntled employees either before or just when they issue proceedings in litigation, can currently issue a subject access request for a fee of £10, and that gives the employer 40 days to often have to do a very strenuous, onerous search of their email system and then provide any emails that contain personal information about the individual to that person. Now, how's that going to change under GDPR? Is it going to get easier for employers?
No.
Disaster in the ring.
So the concept of subject access requests remains the same. It applies to all data subjects. Therefore, all of your employees can still make the request. So the concept isn't going away, and in fact, unfortunately, the position is getting worse. So the requirement under the GDPR is that you respond to a subject access request within 30 days. Currently, you have 40 days to respond. You now are provided with 30 days. It is possible to extend the request, but certainly you need to be acting upon that request as soon as it's received. And something that companies, to the extent that they don't have it in place now, should have a policy or an internal escalation procedure in place so that they know what to do when they receive a subject access request.
If you were hoping that there was going to be a bit more guidance as well around perhaps limiting when employees can bring or put in a subject access request, you're going to be sorely disappointed as well. The current fee is going to be disappearing. That's that £10 fee that can be quite useful sometimes as a tactical measure for just delaying that start of the 40 days. And whilst you'll be given a limited discretion to charge a reasonable fee based on administrative costs, there isn't really any guidance what that's going to mean. There's no restriction on the number of requests someone can put in, and the first copy of that outcome must be provided free of charge. So you can see how this is going to be a bit more onerous. And the obligations on how you provide that information, it's got to be provided in a structured and commonly used and machine-readable form. We're waiting for further guidance around what that's going to mean in practice, but it's going to mean sort of that information overload that sometimes is used as a bit of a tactic in responding to subject access requests. That's going to be much harder to do. If you're getting onerous and problematic requests, you can still always push back around the scope, and that's going to become more important in actually managing these in practice. So it's important when you get a subject access request in, it goes to the right person and they're able to look at it and respond relatively quickly to say either yes, we accept and we're going to start work on it, or we need you to narrow this down. This is far too broad. We can't even begin to make a start. And particularly with that shortened period that Sian's already mentioned, you really need to be thinking about who is responsible, how are you going to respond and manage those deadlines, and how are you going to set it up internally so you've actually got the processes to get the data you need.
Okay, so subject access requests, if anything, are going to get more onerous when this all comes in May next year. Now, there's been a lot of talk in data privacy law generally about the right to be forgotten. How does that apply to HR data and the retention of HR documents?
Well, there's two elements here. First of all, retention of HR data or retention of data more generally under the GDPR. There is a general requirement under the GDPR to only retain data, personal data, for as long as you need it. And that would, again, apply to HR data. So retaining something in perpetuity is never appropriate and is never going to be appropriate under the GDPR, and you will never be able to justify it. But again, it's about looking at the different categories of data that you have and being able to justify the length of time for which you keep that data. So where you've got an employee who's an active employee who's in the business, then it's reasonable for you to justify you retain that piece, that all the information pertaining to that employee. But where, let's say, the employee left the business 3 years ago, you may no longer need bank account details, you may no longer need payroll details in respect of that particular employee, but you need to retain other information about that employee to be able to deal with audits from the accountants, or audits from the tax office, or other issues, or other legal issues that may arise. So there's no requirement to delete or destroy information that you need to keep because it's reasonable for you to do so, or because there's a legal requirement for you to do so. But in each instance, it's about looking at what's reasonable at the time and being able to justify the length of time for which you keep it.
One of the problem areas that we foresee coming up is around things like disciplinary sanctions and grievances. How long do you keep those, particularly if they're going to last for, someone's got a warning for say 6 months or 12 months? And again, it's coming back to this question of how long do you need to keep that for? Do you need to keep it for years and years just in case they have a performance issue 10 years down the line and you might need to come back to it? If you're not going to be able to rely on it in terms of evidencing a performance issue or a conduct issue, you're going to be under some pressure to actually remove it from the system, particularly if the employee asks. On the other hand, if it's still relevant and active, it becomes much more of a question of you need it, and therefore that overrides the data subject's right. One of the points to pick up is around candidate details and how if you're retaining CVs on file, for example, or details of candidates who've come in. And again, it's worth being aware that whilst you may be required to delete those if you haven't taken people on, there may be a reason for keeping them just for a short while around, are you concerned that there might be a question around that candidate's application? Are you worried that there might be, for example, a disability claim coming in around that individual? It's not a, sort of an obligation to delete things straight away, particularly where it might be relevant. But you do need to be reviewing why you're keeping it and how long you're keeping it for, particularly if someone is asking you to delete it and they have the right to be forgotten.
Okay, thanks for that. Now, can you explain how the use of service providers might be impacted by GDPR?
So absolutely. So any service provider. So what do we mean here for HR and HR professionals? We mean here your payroll provider. We mean your HR system where you keep all employee details. Any other systems where the employee gets access and where you're retaining their data. So all of those third-party systems that you use every day as part of your job and part of your management of your employees are retaining or will be retaining employee data. And your requirements as a company and a data controller, as defined under the GDPR, is to ensure that all of the contracts that you have in place with those third-party providers adequately protect that information and ensure that they are always in compliance with the GDPR. Now, I appreciate that some of you on the line won't be responsible for procurement or for looking at the contracts themselves, but there is an obligation here on you to be talking with your legal counsel and your tech teams internally to be making sure that the providers that you are choosing are GDPR compliant, that the provisions in the contracts have been amended so that they comply with the GDPR. And it isn't something you wait till May next year to do. This is something that you should start putting in place now, especially for those contracts that are going to run for the next couple of years. You know, we are already drafting those provisions for clients at the moment, and it's something that will become part and parcel of your contract negotiations.
The other thing to watch out for is if you're using cloud-based HR programs or you have a centralized HR program that's covering a number of jurisdictions, so maybe sort of covering different countries in Europe or covering Europe and the US or the EMEA region. If that data is going to be hosted outside of the UK or outside of Europe, you need to be watching out for it as well and making sure that you are complying with the data obligations that you have to the individuals that it relates to in the UK and Europe.
Okay.
So just to add on that, sorry, before we go on, it's just a practical step is to look at your contract. So not only are you looking at your contracts that you're entering into now, but you're looking at your contracts that you already have in place and retrospectively putting these provisions and protections in. Okay, so continuing on the theme of what should actually be done now, there's always with GDPR a lot of talk about doing an audit. Can you talk us through what that means in the context of HR data and what companies should be doing as we speak?
At this stage, it's a case of really working out what personal and sensitive personal, remembering there's a distinction between those two, data you have, what you obtain, what you process, where it's stored, how it is stored, access, used, processed, the location of it in terms of geographical, and the grounds on which you have that data. Why do you have it, why did you collect it, and why did you process it, and what you share with third parties, and why you do so. It's also a good point to be looking as well at what monitoring you carry out, where that's carried out from, and why you're carrying it out. Basically, what you're trying to build up is a picture and a very detailed picture of where data is, whose data, who has it and why, and that's going to help you going forward, identifying where the risks are and what steps you need to do to take remedial action.
So then once you've done the data audit, so then it's about looking at the doing a gap analysis and understanding what needs to be put in place. In particular, with respect to the employees, we expect you to be putting in place privacy notices. So that has been very transparent with your employees about the data you're collecting, how the data is being used, how it's being processed, who they should contact if they have any questions about the data and how it's being used.
On the employment contract side, a lot of contracts we see have data protection wording in there. And whilst you may have been relying on that at the moment, it's already a bit of a dubious ground, but you're not going to be able to rely on that going forward. It doesn't mean that you need to issue new contracts to everybody. You can leave the wording where it is. It just means that you can't rely on it as a basis and a ground for legally processing that information. And the same goes for policies. It doesn't mean that you need to sort of delete everything that you've got. What it does mean is you need to start looking at what you've got, reviewing and updating it so that it's fit for GDPR purposes. And also maybe cross-referring, so your disciplinary policy should be referring very succinctly and very clearly to data privacy breaches and making sure that it's all tied up so employees, again, it's part of this sort of notification, letting employees know it's a big issue. That's where you have to join the dots as well.
Steph, on employment contracts, so is the expectation that new employment contracts should have specific wording in? Or no wording?
At the moment, there isn't one standard position. It may be that employers want to retain some wording just as, to be honest, a guidance and a deterrent to employees, accepting they're not going to be able to rely on it. The alternative is to stay absolutely silent in the contract and make sure your policies are as robust as they can be and rely on those.
Under the GDPR, there's a general obligation across the whole of any business or organisation to provide training to employees and to other staff working within the business as to the GDPR, the implications of the GDPR on the business, so that everyone is aware. The idea behind GDPR is that privacy becomes central to the business and protection of personal data becomes really important. So, businesses need to be looking at training and how they're going to implement that and roll that out across their employee base.
Okay, so there's been a lot of law here. We know there's going to be a lot of change and things are going to get potentially more burdensome for employers. But on a practical level, what can we at Taylor Wessing do to assist clients who have heard all of this and actually now need to know that they now need to take steps to avoid these potentially huge fines?
So if you are sort of sitting at home and wondering what on earth and where do you start with this, there are a couple of free resources that we have already easily available. The Global Data Hub, Taylor Wessing's Global Data Hub, has some really great resources around employee data and how to tackle certain issues, a bit more detail around the consent point and transparency, those kinds of things that we've talked about already today. And likewise, Law at Work, our employee and employer-specific publication, has a number of good detailed pieces on that as well. We will be sending out, and you'll be seeing shortly, our microsite with our free HR data assessment tool, which should be able to guide you in the direction of the things that you need to be doing at this stage. And we'll be alerting you to that as that's going out in the next few days. But further to that, we're also in a very good position to be able to help you with that audit that we've already talked about, whether that's providing you with a structure for you to carry out a self-assessment and work it out for yourself, or whether it's providing additional support around completing that initial audit and working out where your risk areas are. And likewise, if you've already got an idea of where you think you've got some holes or some gaps between your current practice and what the GDPR will require, we can assist you with meeting those GDPR targets and expectations by way of compliance checklists, support, documentation, and putting together action plans specifically tailored for your company so that you know what to do. Beyond that, we offer specific support around subject access requests, what to do and how to deal with them, whether it's a case of you've never had to deal with one and you're suddenly getting them, because we are expecting to see more given, frankly, the sanctions and how much more it is going to mean to a business, and that with it carries the subsequent threat of what might happen if it goes wrong. And again, we have specific teams who are able to deal with the pensions aspect to it. Don't forget in all of this that if you have a trust-based pension scheme, a defined benefit scheme, for example, Your trustees are also going to be needing to take these actions, and they may well need additional support in understanding what their obligations are and then meeting them. Beyond all of this, we also are able to offer help with things like tailoring policies and putting in place new data privacy and data protection, employee policies, privacy notices, all of the documentation. And it's not just a tick box exercise. Part of what the GDPR is bringing in is this idea of compliance, being able to show that you're complying, not just doing it, but showing and evidencing. And that's where some of this documentation is going to come in really, really handy as part of your evidence. If ever you do have a problem or you're accused of a breach, you've at least got something to fall back on to show that you had the policies in place and you were doing what you could, and this was effectively just an accident or a sort of freak event.
Okay, and so how about talking about some of the more detailed stuff that we can offer clients who really need to get into this in detail?
So we can help with policies, contracts and other documentation, whether that's template documents or supporting you in developing your existing documentation. GDPR is about changing culture. It's a bit of a sort of trite word to use, but that is what it's intended to do. It's less of a shock for Europe perhaps than it is for the UK, but what it means is getting to grips with an understanding of fundamentally changing how you deal with employee data. And that means going back to the roots, looking at data flows, practices and solutions, and we can help with identifying those risks and suggesting tailored solutions specifically for your business. Likewise, we can support and help with training, particularly if there are certain parts of the business that you feel actually could do with a bit more guidance and a bit more of an understanding on the GDPR. And as we've mentioned already, subject access requests, assistance with managing and responding to subject access requests, but also putting in place those policies and procedures and training people so that if they get a SAR in, it goes to the right place and you can hit the ground running immediately rather than sort of reacting in a panic, which is quite often what happens at the moment, simply because it's not that high up on the agenda compared with everything else that HR teams are expected to deal with. One of our areas of expertise as well is around dealing with data breaches and high impact responses to that. And that can be assistance with investigations, audits, crisis response. So you've had an employee who's sent out sort of 2 million customers' details to their own personal email account. It does happen, and it's good to have in place all of the response and processes that you will need so that if that happens, you can respond quickly, protect your business, but also protect yourself in terms of the ICO and any further action that may be taken.
Okay, well that was a bit of a whistle-stop tour of the HR side of GDPR. I appreciate that was an awful lot to take in a very short period of time. Do please contact us if you have any specific queries. On the screen you have all of our email addresses. As Steph says, we are going to be sending out a flyer with some of the particular HR data privacy products that we're launching in the next couple of weeks. But as this is so often about something that has to be tailored to your particular business, it would be great if we could speak to you and potentially help you in complying with this new law. As we said, it's May next year, but really businesses do need to be taking active steps, putting the right policies and processes in place right now. Thank you for listening. I hope you found that useful, and I hope you have a good rest of the week.